Well, it's been quite a busy day today here at KingCast. We have another visit from SCOTUS. This time they're reading about the ongoing No Child Left Behind fraud in Columbus, Ohio that we've been exposing for the last 5, 6, 7 years now, my friends over at justiceforkids.net. You can see they're reading all about the no confidence vote for Gene Harris, the superintendent, unheralded. Now, meanwhile, back here on the East Coast, we've got a problem. We've got Charles Glenn's case. This man had evidence withheld from him illegally, okay? Had a perjuring white witness that they're putting back on the stand again. There's David Ridley. He was improperly arrested for being a journalist. Okay. We have Mike Gannon and Pamela Reynolds, also wrongfully arrested for taping the police. That Ridley was taping the police too, by the way. They didn't like that. Okay. We've gone to the FBI about this. Gannon and Reynolds and I did. And now that in my case, it seems that I can videotape and shoot the president up close, no problem. But then when it comes to people like Kelly Ayotte and Joe Arpaio, they threaten to arrest me. And I don't really understand why they do that or why they think they can do that. So anyway, they get this judge who's well connected to them, the law firm of McLean Graff, and I file a motion for disclosure and then a motion for recusal under 28 U.S. Code 455. The judge says it's without merit entirely, but then she goes and recuses herself, okay? But she didn't do it the normal way, as you can see. She did it like this. That's the only place it shows up, all right? And I threatened to, actually I did file a motion to vacate her order in my case because she had issued bogus findings of fact and all that when I applied for a TRO. Now you got this guy, okay? That's Brian Cullen. He's the Nashua attorney for the police department. He's threatened to file for sanctions against me, all right? Going back to the 1990s when I was in trouble in Ohio for being a vigorous civil rights advocate, I had basically tape recorded a landlord who called my client a nigger lover. All right. Well, the problem is, if he's going to bring this into the case as he threatened to, he's got skeletons in his own goddamn closet. All right. Look at it right there. All right. He was found in contempt of court, he and his client, in New Hampshire recently. All right. In the same federal court where we are operating. Okay. The first time was in Sam Bourne's case. And then again, well, he hasn't been found in contempt yet, but some documents popped up that they failed to provide to Ralph Holder, who is a decorated serviceman, a police officer, retired police officer, and they basically criminalized this black man, took his child and sent the children over to an inferior school, took him out of New Hampshire and put him away to a different school in violation of Palmer versus Sidati and Brown versus Board. They used race as a criteria to do that, to get him out of the white area in New Hampshire into an inferior school in Massachusetts. Okay, that's how the game is played. Anyway, there was some documentation, as you can see there, that indicated that Mr. Holder had never abused his wife. Okay, and now he never got that information. Now he's telling Brian Cullen, you better cough it up, explain why I never got that information. Okay, let's see what happens now. We're here at KingCast.net. It is September 8th, Thursday, September 8th, 2011. We're going to discuss briefly judicial ethics and the lack thereof relative to Landry B. McCafferty's quiet recusal in my free press racial litigation, which is case number New Hampshire District 2010 CV 501. Basically, this is simple. As you can see by the chart that I'm going to show you now, Landry B. McCafferty, okay, this judge worked underneath Jack Middleton, who founded McLean Graff. You had Kelly Ayotte over there, who left right before McCafferty got there. You have James Muirhead, who trained her. Then you have Jennifer Parent, who is now the head of the New Hampshire Bar Association, the president, okay? She worked on ethics panels, as did McCafferty, okay, in discipline, attorney discipline. Then you have a bunch of New Hampshire Bar program faculty attorneys who also work for McLean Graff. All this kind of association went unbeknownst to me, the plaintiff down here, okay? That's false. It's not false because it happened. But what it is it's false justice. It's unethical. We've all been federal litigators. I've tried, won, lost, and settled federal and state cases as an assistant attorney general and on my own. And you can't do that. You can't not disclose that. He's accusing me now of filing a frivolous action.
and trying to get the court to set aside her report and recommendations. Well, he says, well, you were in contempt of court in Ohio and blah, blah, blah. And well, that was from conduct back in the 90s when I was a vigorous civil rights litigator there. But here's the pot calling the kettle black. This guy was found in contempt of court recently in New Hampshire. Okay, so he's going to file a motion talking about how I've been held in contempt of court. Talk about the pot calling the kettle black counselor. All right, file your motion. And we'll see how it holds up when we get to SCOTUS.